Copyright law creates rights for authors to stop others from copying their original creations, including literary works, such as written words and software, musical works, such as pop songs, artistic works, such as graphic designs, and dramatic works, such as scripts that are capable of being performed, and also the secondary types of works, such as films and sound recordings, most often in the MP3 digital format. These latter types of works are secondary because they necessarily are comprised of other copyright works. That is, a film will include at least one literary work, the screenplay, but perhaps also an adapted original novel, and will often also include musical works, such as the score or perhaps background music, and may even contain artistic works, such as wall paintings or graphic designs or within some part of the picture. Because of the inclusion of these works within works, most commercial films must go through the legal clearance process to ensure that every such work contained within the film is properly licensed or is for some other reason lawful to use. A failure to obtain every clearance could potentially result in a copyright infringement claim against anyone or everyone involved in the exploitation and use of the film, that is, the filmmaker, the distributor, the website, the internet service provider, and perhaps even the registrant or the registrar of the domain name through which the infringing film has been streamed or downloaded. Put simply, every act of copying, performance, distribution, or adaptation of a copyright work requires that a license is in place or that a legal defense is available. Even the copying of your own legally purchased CD onto your own iPod is a copy and is unlawful in both the UK and in the US. Likewise, every website upload of an MP3 file or a video clip is a copy and will be unlawful if no license has been obtained and if no legal defense is available. Websites that allow its users to upload and share their personally chosen materials are called user-generated content websites, or UGC sites, because the content on these sites is sourced directly from the user. It's uploaded to the site by the user without any human supervision, intervention, or moderation by the website, and is therefore generated by the user rather than the website. The largest of the UGC sites is, of course, Google's YouTube. So why are sites such as YouTube, containing large numbers of infringements, still going strong? YouTube, like all of the user-generated content websites, may rely on one or more of the following defenses or exceptions that are available under European and UK law. The first is known as mere conduit. Under EU and UK law, YouTube may be regarded as an information service provider, insofar as, like the phone company and the post office, it is a passive transmitter or communicator of information of which it has no actual knowledge, and therefore YouTube may avail itself of the mere conduit exception. Under this defense, a service provider is not financially liable for information passing through its network, provided that the information service provider, that is the website, does not initiate the transmission, select the receiver of the transmission, or select or modify the information, and, crucially, has no actual knowledge of the infringing materials. This exception only applies to information that is not stored any longer than reasonably necessary or for any purpose other than as directly related to the transmission of the information. The second defense is closely related and is often referred to under the name mere conduit, but is in fact the caching and or hosting exception. As an information service provider, a UGC website may avail itself of the EU and UK caching and hosting exceptions, which, like the mere conduit exception, is under the e-commerce regulations. And under this defense, an information service provider will not be liable where the caching is automatic, intermediate, and temporary for the sole purpose of providing a more efficient service, or in relation to unlawful information which is stored by the ISP where that information has been provided by a third party using the service. This exception applies only where the ISP does not initiate the transmission, select the receiver of the transmission, or select or modify the information, and provided the service provider has no actual knowledge of the infringing material, that is, it This results in the well-known takedown notice regime, in which the copyright owner may give an ISP actual knowledge by writing to them, and the ISP must then expeditiously remove that material.